Your matter did not settle at Conciliation Conference and you've now had your matter listed for hearing. What does that mean? My name is Gemma Bunner. I'm one of the principal lawyers at Shaw Bunner Legal, and this video is going to talk through what to expect when you have a matter that proceeds through to hearing in the residual jurisdiction of the District Court, the Coal Miners Workers' Compensation List. So the Conciliation Conference was all about trying to resolve the matter, and unfortunately it hasn't been able to resolve. Therefore, the court will now allocate a hearing date, and that hearing will take place in either the Newcastle sittings or the Sydney sittings on a date that will be set. We will now take steps to brief a barrister who will appear on the day of the hearing in your matter. You will have an opportunity to speak with that barrister in advance of the hearing date. In that discussion, we will have a general chat about your matter and also answer any questions that you may have about the court process. On the morning of the hearing, we'll ask that you get to court around about 9 a.m. in the morning, which is an hour before the court commences. That will give us an opportunity to meet with you in person, to sit down with the barrister present there as well, to talk about your matter. Now, on any given day, there may be around 3 or 4 matters listed for hearing, and each of those matters will have a number in the list. Your matter may be number 1 or it may be number 4. The relevance of that is if number 1 is unable to be resolved and starts running before the judge, that might push the other matters out that day, and your case may not necessarily be heard on that first listing date. The reason the courts list a few matters on any one day is that they know that the parties, once they're all together, have an opportunity to explore resolution, and in most cases, some sort of agreement or settlement may be reached on that morning of the court hearing. In your matter, you will have an opportunity to explore further negotiations and settlement prospects. So even though the matter has been listed for hearing, that does not mean that you're coming along to court and going straight into the witness box to have your matter heard. So please come along with an open mind and be open to listening to advice, and we'll use our best endeavours to see if we can resolve the case without it necessarily having to proceed to a hearing. If it can't be resolved, and if your matter is placed in the list that it can get a start, then we'll proceed through to running the case before the judge on that day. Try not to be alarmed by that process. It is very much a managed process, and we'll be with you every step of that way, and we'll have an opportunity to talk through giving evidence in the witness box and what you can expect from that process, including the cross-examination. Now, when you come to court, just wear smart casual. You do not necessarily need to be in a suit, but please no thongs or shorts. Smart casual is fine. It's also helpful to bring something to read with you. There is likely going to be a little bit of waiting around. So if you have any questions about the court process, please reach out to the friendly team at Shaw Bunner Legal. We are here to help.